They're courting disaster by encouraging others to use the same means to eliminate those portions of the Constitution that they don't happen to like. Harvard's Lawrence Tribe on every liberal shortlist for the U.S. Supreme Court, and Yale's respected liberal scholar Akil Amar. They acknowledge there is an individual right to keep and bear arms, albeit it can be limited by reasonable regulations in the interest of public safety. So in that sense, Tribe and Amar and Dershowitz, they agree with gun rights advocates on two fundamental issues. The first is that there is indeed an individual right, not merely a collective right. And the second is the right isn't absolute. It is subject to regulation. So to the extent there's disagreement, it hinges on what constitutes permissible regulation. That is, where do you draw the line? Unfortunately, help was on the way. In Washington, D.C., which was, at the time we brought the Heller case, the only judicial circuit that did not flesh out its view of the Second Amendment, the U.S. Court of Appeals for the District of Columbia Circuit had another opportunity to interpret the Second Amendment and the 1939 Miller case. The case in Washington, D.C. that you know as Heller actually started out, it was called Parker versus District of Columbia. I'll tell you why it changed in just a moment. But it was a straightforward constitutional challenge to D.C.'s draconian gun law. It was litigated by Clark Neely, who's the senior attorney at the Institute of Justice, and me, and then the two of us hired Alan Durham, who actually argued the case as a private attorney in the Washington, D.C. area, and we litigated this on behalf of 6 law-abiding D.C. residents who wanted to possess a functional firearm where they live and sleep. So Heller was not about machine guns. It was not about so-called assault weapons. It was about the right to own an ordinary garden variety handgun. And the Heller plaintiffs did not ask for permission to carry the gun outside their home. That is another question for another day, so it has to be litigated. Indeed, it is being litigated as we speak. The Heller litigation, however, is very simple. It's got a pistol in the gun, in the home for self-defense. You probably know that off and on over the years, Washington, D.C. has reclaimed its title, not just the nation's capital, but the nation's murder capital. The D.C. government has been totally ineffective at disarming violent criminals. It's done a really superb job at disarming all of the peaceful and decent citizens in Washington, D.C. So these were the laws when the Heller case was litigated. For starters, no handgun can be registered in Washington, D.C. since 1976. That's 32 years before the Heller decision. Across the board, no handgun. Now, suppose you had a handgun in 1976 when the ban was passed. You could keep it. It was grandfathered. You could have it in your house, but you couldn't carry that gun from room to room in your own home unless you had a permit. The D.C. had an issue with permit for 32 years. How about a long gun? So you had a rifle or shotgun. Yeah, you could have that, but it had to be unloaded. And if you loaded it, you're subject to arrest. It also had to be either trigger locked or disassembled. So unless you were planning on clubbing somebody over the head with that, and the rule of D.C. was that nobody at any time, in any place, could have a functional firearm in their own home. The law applied to every resident of D.C., not just to unfit people like felons and some felons, minors, and crazy people. Applied to everybody across the board, every resident of D.C. There were a lot of challenges, more than 3 dozen challenges to Washington, D.C. government. But they were invariably filed by criminals who were serving longer sentences using a gun in carrying out of a crime. The Heller case was quite different from the Silver. The original plaintiff, as I mentioned, was a lady named Shelley Clark. She lived in a high crime neighborhood in Washington, D.C. People on her block were continually harassed by the drug gangs and the addicts, and she decided she wanted to do something about it. She calls the police, and she complains. She does it time and again. She encourages her neighbors to do the same thing. She organizes block meetings to discuss the problem, and for her audacity, she's labeled as a troublemaker by the dealers, and they threaten her at every opportunity. So a year before we filed the case, that window of the car was broken, a large rock was thrown through her front window. Somebody stole the security camera in front of her, the outside of her house. A drug user actually drove his car into and through the back fence of her house. And then in the year we filed the case, a dealer pounded on the door of her home trying to pry his way in using the crowbar, cursing and yelling, "Bitch, I'll kill you. I live in this neighborhood too." He's charged with felony threat. He's acquitted, heard a word against his word. Shelley Parker knew that the police in Washington, D.C. were not going to do very much about the drug problem on her block, and she wanted a functional handgun to be able to defend herself, but she feared arrest and prosecution because of D.C.'s now unconstitutional gun ban. The second plaintiff, the plaintiff for whom the case is now named, Dick Heller, he was a private police officer, worked for a private firm, and he spent every day carrying a gun and guarding the marshal office building in Washington, D.C. And when he applied for permission to take that gun home to protect his own home and his family, D.C. Said no, just as they say no to everyone. A third plaintiff was a gay man who was assaulted outside of D.C. on account of his sexual orientation. He's walking to dinner with a co-worker, and he encounters a group of young thugs who start yelling, "Faggot, homo, queer, we're going to kill you, you'll never find your body." Well, he was not in D.C. He had a handgun in his backpack and pulled it out, and predictably his assailants were not quite as brave as they had been before. He couldn't have done it in Washington, D.C. So the six plaintiffs in the Heller versus District of Columbia asked a federal judge to prevent D.C. from barring the registration of handguns across the board, from banning the possession of functional firearms within the home, and forbidding these firearms to be carried from room to room without a permit, which you can't get. The plaintiffs lived in the district, they paid their taxes in the district, they paid the laws in the district. The D.C. said if somebody breaks into their home, their real choice is you call 911 and pray that the police arrive in time. If you've ever been to D.C., you know that's not a high probability, right? You can actually get a pizza delivered before you go 911 in Washington, D.C. Well, in March of 2007, the D.C. Circuit, the second highest court, the U.S. Court of Appeals for the District of Columbia Circuit, Senior Judge Lawrence Silverman issued what I think is fair to characterize as a blockbuster opinion in Heller, and he held that the Second Amendment protects an individual right to bear arms, and then he continued, and this is the quote, "The right is not limited to malicious service, nor is the individual's enjoyment of the right contingent upon his or her continued or intermittent enrollment in the militia." So with that historic proclamation, Washington, D.C., the D.C. Circuit became the very first appellate court ever to overturn a gun regulation on Second Amendment grounds. 68 years before that, you had this Miller case, which mistakenly concluded that Second Amendment rights attached to specific weapons, not to specific people. The holding in Miller was that the sawed-off shotgun, which was at issue in Miller that they carried across state lines, had to bear some reasonable relationship to a well-regulated militia. And since there was no showing in the case that there was a relationship between sawed-off shotguns and well-regulated and efficient militias, therefore that regulation was permissible. Now that's perfectly reconcilable with the Heller case. So Miller was not overturned by the Heller court. All Heller said is that there is a right that attaches to individuals as well as to weapons. And in this case, the weapon at issue was a pistol. And pistols, self-evidently, are related to the efficiency of a well-regulated militia. They are specifically mentioned in the Militia Act, and in fact they've been carried into battle by American troops every conflict since the Revolutionary War. So there's no conflict between the Miller case, which said that the right attaches only to weapons which preserve the efficiency of the militia, and the Heller case, which says, well, in this case, the weapon does preserve the efficiency of the militia, and by the way, the right attaches not just to militia members, but also to individuals. For those of us who were eagerly awaiting a comprehensive, and I think comprehensible, Supreme Court statement on the Second Amendment, at least default the Miller case, the Constitution was on our side. Now that didn't mean that the D.C. government couldn't regulate firearms. Silverman, in his opinion, and Justice Scalia has said much the same thing in his opinion to the Supreme Court. They conceded that the protections of the Second Amendment are subject to the same sort of reasonable restrictions that apply to other amendments, like the First Amendment. If you pick up the Constitution and you read Amendment number 1, it says, Congress shall make no law infringing on free speech. Now, I don't know what could be clearer than that. Congress shall make no law. But what do we have? We have laws that say you can't engage in certain forms of pornography. You can't falsely shout fire and fabrication. You can't incite to riot. You can't lie in commercial advertising. You can't engage in some forms of political speech connected with the campaign. So when it says Congress shall make no law, it means Congress makes all kinds of laws. So these protections, the amendments of the Bill of Rights, they're not absolute. What they do is they set up a presumption. The presumption is you have the right, it's government's burden to justify any imposition on that right. So Silverman and Scalia both said, well, perhaps D.C. could justify things like concealed carry restrictions or registration or proficiency testing, or certainly no gun possession by violent criminals or by crazy people or by 7-year-olds. But what they can't justify is an across-the-board ban on all firearms in all places for all residents at all times. That's not a reasonable restriction. In fact, it's not a restriction at all. It's an out-and-out prohibition. And both the D.C. Circuit Court and the U.S. Supreme Court agree.